Thabiseng, I must ask you, why, there's so many facets of, especially the public, that say that this is just a little bit too harsh. What are your views on the matter?
Well, the sentence really is harsh. The charge basically is malicious damage to property that he was originally convicted of. Hence, we are here when he now wants an appeal regarding the conviction. But here's the problem. The original case, when the quota quo who heard the case originally, should have, the person who was representing him there should have advised him accordingly. If the evidence, as now we are now being told, does not put him anywhere in the scene, then him having pled guilty should not have been an option. So now he unfortunately pled guilty, which means admitting all the elements of the crime, and therefore even trying to appeal the sentence or conviction is a fruitless exercise. What I would have appealed against, probably as the new attorney on record, would probably have been the sentence instead of the entire case, which is the conviction and the sentence, and request that the sentence be reduced. So because now the appeal was for every single aspect of the case, both conviction and sentence, hence it was dismissed. Therefore, there's no need for him to get bail under the rule of law in this situation.
This issue around, because really the case is against malicious damage to property, right? If it's malicious damage to property, I'm no legal expert, that's why you're on my table this afternoon, but one would say that, do you really get 5 years for malicious damage to property? Do you get 8 years for malicious damage to property? No bail? I mean, for malicious damage, you know what I'm saying? Like,
I understand where you're coming from, and I've done numerous cases for malicious damage to property, and usually it's when there's protests such as this one, you know what I mean? And police cars do get damaged, but usually the accused persons are released out on warning. It doesn't matter how much the damage is. You must remember that what the proportion of the damage versus the bail is usually what it's worked upon. Okay. But when it's a lot of people that are involved in the situation, such as Weeds Must Fall, and there was a lot of people involved in the fighting and all of that, then when it is now deemed as public violence. So now when they're all appearing in court, they're usually all released out on warning, which is basically free bail.
And it's not the first time that we've seen malicious damage to property or police van in this case, right? So, and I'm not saying that he did not do the crime, yes, and I'm not saying that he should not have done the crime, but when we're looking at the fact that malicious damage to property, especially within the context of a protest action, he should have been released on a warning, or at least community service.
He should have been released on warning, period. Community service is when now the case is now in. Myself as his attorney will now be speaking to the NPA or the prosecutor at the stage saying, okay, we are willing to admit certain parts of the acts that we done on that day. Can we now look at diversion? Now this is where we what you just mentioned right now, doing community service and stuff now comes in. And then the accused can now do community service, etc., in order for the case to not be withdrawn against him, and then he goes home without a previous conviction. That is the avenue that we usually take. Okay. But now, whoever was his attorney in the quota quo has now messed up his life, because now he's stuck with a previous conviction. And on top of that, he's now left with a sentence of about, 8 years now? Of a sentence of 8 years for malicious damage to property.
I'm not even going with the attorney, Thabiseng. I'm going with the individual that actually ruled, the sentence in itself. So who's got it in for this? And I'm not being suspicious, but why would you put in a measure of that kind of that many years, that steep sentence for an individual that was in a Weeds Must Fall protest?
My question would then be rather his SAP 69s, so his previous convictions. So if he has previous convictions that we're not aware of, that could have accumulated to him getting the kind of sentence that he got today. But if he was a first offender, then the presiding officer should have taken that into consideration above anything else. And then he would have gotten even the 8 years, but suspended for a certain period of time. That way he would be home by now. So now we're probably looking at his history, his criminal history. We don't know what the SAP 69s read when the prosecutors read them into record. We don't know his criminal history. That always contributes to the kind of sentence you will get. So probably he has maybe more than one, or in fact 2 previous convictions of the same kind of crime. Then he got a suspended sentence in one, and maybe in the other he got a 2-year direct imprisonment. It would make sense why he gets this sentence today. But if he is a first offender, then it does not make any sense.
And that's where we have to leave it. You're going to turn me into a lawyer. By the time we're done here, you're going to make me into a legal expert then. Thabiseng, thanks for joining us this afternoon, shedding some light in terms of this, Khanya Xekesh's case as it is ongoing, as you see that he's been denied bail. And, of course, the mystery continues.